This is the criminal process element 2 regarding questioning and accusation as it is outlined in the Fifth Amendment to the U.S. Constitution. Now, like we did with the Fourth Amendment, what I'd like you to do is go to the Fifth Amendment in your Constitution and do a little bit of annotating. Underline the main points, the key ideas, the key words, I guess you'd say, and jot those main points down in the lesson. So, stop the video once again, right now. The most famous part of the Fifth Amendment is obviously the ability to plead the Fifth. These are the rules about self-incrimination, and it basically says that you do not have to be a witness against yourself or provide evidence against yourself in any way. And yet, there is a time when you may want to be a witness against yourself or provide evidence against yourself, and that has to do with cases of immunity. If the government guarantees a suspect immunity, this means that they're giving them exemption from prosecution in exchange for their testimony regarding their own or others' misdeeds. It's typically in a case where you've been a key witness to something that somebody else did, but you don't want to say anything about it because you'll go to jail too. Well, if the government grants you immunity, then you are basically going to come right out and say all the things that you did because they've made you immune from prosecution. They're using you to get the other guy, so go ahead and say whatever it is that you did because you're protected by the government. In that case, you obviously wouldn't want to plead the Fifth. The most famous U.S. Supreme Court case that deals with the accused's right to not incriminate themselves is the Arizona case Miranda versus Arizona in 1966. Ernesto Miranda was picked up as a prime suspect in the rape and kidnapping of an 18-year-old girl. The girl identified him from a police lineup, and he was questioned by police for 2 hours. But during this time, they did not tell him of either his constitutional right against self-incrimination or his right to counsel. In fact, it's probably unlikely that Miranda even knew what the Fifth Amendment was. So he said enough to eventually lead to a conviction, and when his lawyer got wind of this, they appealed to a higher court. The U.S. Supreme Court reversed his conviction on appeal in the case Miranda versus Arizona. And it was in that case where they said that since Miranda did not know his rights because he wasn't made aware of his rights, that one of the most famous things that's ever happened in American legal history took place. You hear it all the time in crime dramas and movies, and it begins with one simple phrase. You have the right to remain silent. Now, I'm sure you've heard this on a TV show or in a movie, or if you're really unlucky, in person. But basically, this is what police officers have to tell you ever since the Miranda versus Arizona decision in 1966. They have to let you know that you have a constitutional right to remain silent and may stop answering questions at any time. They have to tell you that what you say can be used against you in a court of law, and they have to tell you that you have a right to an attorney during your questioning, and that the court will provide an attorney if you cannot afford one yourself. These are called your Miranda rights after the court case, and police officers typically carry this card around with them if they don't already have it memorized to begin with. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning. If you wish, you can decide at any time to exercise these rights and not answer any questions or make any statements. And of course, on the TV show, they'll always say, "Do you understand these rights as I have read them to you?" That's not really what it is. It's actually a little longer than that, and it's a part of the waiver that's located on the back of a Miranda card. As you can see here, they have to ask the person if they understand these rights, and there really isn't any getting around that. Otherwise, you'd be sitting there for 2 hours while someone plays dumb and pretends not to understand what you told them, hoping to get their charges thrown out in court. Really, if you explain it to them once or twice, the court is going to uphold that you must understand what your rights are. The bottom line here is that they're going to give you an opportunity to waive all these rights and just fess up to the crime right away. And if you acknowledge that you do want to waive those rights, then you're willing to sit down and talk with them. This is the kind of thing you see that happens in interrogation rooms and things like that when a guy just says, "All right, I'll talk." But of course, the Constitution has a lot of loopholes, and there are some exceptions to Miranda rights as they stand. For example, in 1991, the court held that a coerced confession introduced in a trial does not automatically taint the conviction. If other evidence is enough for a conviction, then the coerced confession is just a harmless error that does not necessitate a new trial. In another case in 2000, the court made it clear that it supported the Miranda decision and that Congress was not empowered to change it. And in 2010, the court held that police may take a second run at questioning a suspect who has invoked his Miranda rights, but they must wait until 14 days after the suspect has been released from custody. The court also declared that criminal suspects seeking to protect their right to remain silent must speak up to invoke it. However, even with the exceptions, we know that at its core, the Fifth Amendment prohibits coerced confessions. But most people don't know that it also prohibits coerced crimes. The courts have overturned convictions based on a term called entrapment, when a law enforcement official encourages someone to commit crimes, such as accepting a bribe or purchasing illicit drugs, that they otherwise would not commit as a part of their normal routine. Now, if you're doing this as a police officer to someone who routinely does this and is known to do this, and this is a commonplace thing, well, then it's not entrapment, and it's most likely going to be able to be used in court. But if you are selling drugs to someone who normally does not use drugs, it's not a part of their normal habit, it almost seems like you're just out to get them. In other words, out to trap them. And in that case, it could be thrown out as a measure of entrapment by a police officer, because they're doing something and getting someone to buy something like illicit drugs that they normally wouldn't buy. It's just a one-time thing. Okay, so let's say we've gone through the process of questioning. What happens next? Well, in the Fifth Amendment, that's really up to the grand jury. Now, a grand jury comes from the Latin word for big, grand. You've seen that in various languages that are Latin-based, like Spanish or French. Grand with an E at the end indicates something large. The grand jury is the large jury, usually 13 to 25 people. But the thing is, grand juries usually aren't the ones that you see on the crime dramas or the movies or whatever the case may be, because they're not really part of the exciting part, the criminal trial. That's because their role is not to decide innocence or guilt. Again, the purpose of a grand jury is not to decide innocence or guilt. The grand jury is there to look at the evidence and decide if there is enough evidence to move on to a trial. Now remember, we're talking about the Fifth Amendment here, which is about questioning an accusation. There's nothing here about seeing if someone's guilty or not guilty. So again, that is what the grand jury does. They just decide if there's enough evidence to proceed ahead with a trial. And if they do decide that there is enough evidence to proceed with a trial, what happens next is called an indictment. That is a formal accusation of a crime. That means they are formally accusing you of doing something wrong, and there is enough evidence to proceed ahead with a trial. The document in front of you is an indictment that was placed on Michael Jackson back in the day, 2004 to be specific, and it was basically accusing Michael Jackson of various crimes. They were basically saying, we've seen the evidence, we think there's enough here, and now we are formally accusing you of a crime and moving on to trial. But despite the importance of their purpose, grand juries are rarely used. I can't remember the last time we had a grand jury indictment in this area, much less the use of a grand jury. They're basically set aside for high-profile cases, and there's a couple of reasons for that. The first one has to do with the prosecutor. The task of the prosecutor is usually to charge someone with a crime based on the evidence that they've been getting. Now, for lower-profile cases, that's not a big deal, but for a high-profile case, there could be a lot of external pressure on someone about what they're going to do when it comes to charging someone with a crime or not. So in order to take the pressure off a prosecutor, to take the burden off the shoulders of one person, grand juries are brought in to basically help out a little bit and alleviate some of that pressure and make that decision spread out among 13 to 25 people. The other reason grand juries aren't used very much is there's a lot of expense involved. You've got to go through a jury selection process, and you've got to go through the normal questions to select that jury. That costs a lot of money and takes a lot of time. So grand juries are set aside for high-profile cases. But what about cases that may not be high-profile enough to warrant a grand jury? As a matter of fact, we're talking about most of the cases in the country, so what happens there? Well, what happens there is what's called a preliminary hearing. In a preliminary hearing, once again used in lower profile cases where a grand jury may not be necessary, The lawyers will simply go before the judge to take a look at all of the evidence, and it is the judge who will decide if there's enough evidence to move on to a trial. At that point, it's all presented over to the prosecuting attorney, and the prosecutor's job is then to issue the charges to the accused. That is what the grand jury normally does with their indictment. Another key component to the Fifth Amendment is the concept of double jeopardy. Now, this means that if you are acquitted of a crime, in other words, found not guilty, acquitted of that crime, then you cannot be put on trial for that particular crime again. So if you're found not guilty of murdering your ex-wife, no matter how upset her family may be, they cannot appeal that decision to a higher court, because you, since you've been found innocent of the crime, cannot be put on trial for the same crime twice. You've been acquitted and you are protected against double jeopardy. Now, don't confuse this. We're talking about that particular case, that particular murder of your ex-wife. It doesn't mean you can just randomly go around committing murders thinking that you've been acquitted of murder. Now, you've been acquitted of the murder of your ex-wife. You kill somebody else, that's an entirely different case, and yeah, you can be tried again for that. And not only does the Constitution protect you if you're acquitted of a crime, but it even offers you some safeguards if you're found guilty of a crime as well. If you're found guilty of a crime, you can appeal that decision to a higher court as long as they're willing to take it and look it over to make sure that you haven't been wrongly convicted. The recurring theme in all of this, of course, is the idea that the Bill of Rights were set up as a series of protections against this new, more powerful government that was created by the U.S. Constitution. The American people, when they were colonists for England, had been subjected to various unfair laws by the king, and they wanted to make sure that would never happen again, and that is evident in the criminal process from the Fourth Amendment on. Remember, if you are acquitted of a crime, you are protected from anybody coming after you about that crime again, and if you're found guilty of a crime, you get a couple of second chances, if those courts are willing to accept to hear your case, to try to get your conviction overturned. It's all set up to protect the rights of the citizens. Which brings us to something else designed to protect the accused, the Statute of Limitations. Now, what this basically means is that if a crime has been committed and they want to accuse you of it and put you on trial for it, they have a given amount of time in which to come up with enough evidence to make that happen. If they don't come up with enough evidence in that time, then you are off, scot-free. You could tell anybody you want to about it, and they can't put you on trial again for it, because the idea is they're not going to let somebody have an accusation hanging over their head for the rest of their life. They're going to cut this off at some point. So let's say, for example, the statute of limitations for murder in the state of Michigan is 30 years. I don't know if that's what it is, but that's what I'm going to use for the example. They're going to take those 30 years to try to gather as much evidence as they can to bring you to trial. And if they can't do it within those 30 years, then you are off scot-free and could tell anyone you want to about it. Now, one thing to remember about the statute of limitations is that it's different from state to state. The statute of limitations in Michigan for murder might be 30 years, but in California, it might be 25. And it's important to remember that the statute of limitations is different from crime to crime. Take Michigan, for example, where the statute of limitations for medical malpractice is 3 years. It might be 10 years for armed robbery and 30 years for murder. Take a look at the state of Nevada, and as we know, it's different from state to state. The statute of limitations for medical malpractice there is 4 years, but it might be 15 years for armed robbery and 35 for murder. Or in Maryland, where the statute of limitations for medical malpractice is 5 years, might be 17 for armed robbery and 28 for murder. It really depends on the state and what they want their statute of limitations to be for each crime in their state. It's ultimately their choice. So it can be different from state to state and from crime to crime. And when it's over, you can tell people about it. They can't come after you anymore. There was a guy in 1972 who was the getaway car driver for a raid on an FBI office in Philadelphia. He evaded the FBI, he moved to northern Michigan, and eventually became a bus driver for Glen Lake Community Schools. Once the statute of limitations had passed on it, the family told the story to the Leelanau Enterprise, and that was pretty interesting. Okay, that's it. Thanks for listening.